environment at play, you see it leak up into this particular decision, or I guess trickle down into this decision. Or is it that Moby Dick sort of starts out as like a frame in which the court sort of begins to sort through their arguments on this particular decision? I don't have enough background about Berzon or the Ninth Court to really know how they went about making this particular decision. So I sort of leave it at, my sort of feeling is that what you're seeing is the Moby Dick and the allusions to it are a sign of sort of the logic that's playing out in this particular decision that's probably, that the court may never draw upon again. That the unique sort of circumstances of this being about whaling, the mess of Native American sort of multicultural recognition, and then international law on top of it just makes for almost a perfect combination that rather than having to wade through all of this, we sort of have an easier object in our cultural sort of memory and legacy to draw upon that helps resolve a lot of this sort of mess. So, the majority of this is published in an article in Common Law Review from 2010. So there's some skipping around that I've done, so I encourage you, it's online, copy of it, under the same title, I believe. So if you'd like to read a little bit more specific details as I've derived some of the arguments about the decision, please feel free to look at the article. But I'd be happy to answer any sort of questions or any reaction folks might have.
Please, the floor is open for question and discussion, or rebuttal even.
Yeah.
I just have kind of like a clarification.
Sure.
I haven't read Moby Dick, but are you saying that like where the small bits of whiteness come in, it's through the use of like Moby Dick as like a hegemonic text, or I was just a little bit confused about like.
I'm not sure that I'm arguing that it's a. I'm not sure hegemonic text is the way I would describe it. I mean, the argument I'm trying to make is that Moby Dick itself as a piece of American literature is a very powerful piece. The article kind of goes into more detail about the history, and along with the story of Moby Dick, why it has haunted American imagination for as long as it has. But in this particular instance, the argument is just that in drawing upon this, that it operates as basically an easy way to say it would that it operates as sort of precedent. Like as I call it, a literary truth. That it just becomes, let's think back on our sort of history with whaling. We normally think of whaling as its ugly commercial sort of days. And, for people in the modern age where whaling hasn't been legal, and it officially hasn't been legal in 30 years, where we stopped the practice of whaling long before that. That Moby Dick is what we draw upon as our sort of understanding of how whaling, what whaling practices and the sort of harm to the environment that it caused. And so what I'm saying is that becomes sort of for this court a way of precedent. Like we don't know how to resolve a lot of these legal issues, but there's always sort of Moby Dick, or more importantly, the logic behind it of when we confront whales, right? And Moby Dick informs us a lot about how we understand whales, that they are the sublime. They're beautiful, they're majestic, but they're also powerful. A whale can destroy any of us, instantly. And so that we should always respect the whale. And you can look at environmental advertisement and a lot of environmental campaigns that really build upon that imagination of the whale, or that cultural understanding of the whale. That whales are very, have high intelligence. They are mammals. They're very close to humans. You have movies like one of the Star Trek movies, I don't remember which number, 4, right? It's like Hunt is they find a whale that teaches them about sort of the ways of the world and what happened, I believe, to Earth. Is that right, Nathan? Mm-hmm. Yeah, we have this sort of imagination, or you have movies, that incorporate whales, that that they are sort of majestic sort of beings. So we've always held a very respectful sort of attitude towards them. And it's not just that way when we confront an actual whale like we're whale watching, but very much in our cultural imagination. Yeah.
Yeah. So the short form of your critique is that whales are sublime. The whale is sublime. The whale is beyond our ken, really. More powerful than we could ever be, uncontrollable to us. And we should not hunt it because it is wrong to hunt.
No, that's not my argument. I mean, I don't take a stance on.
I mean, what the court was.
Oh yeah, in terms of the court.
not
Yeah,
you.
yeah,
No,
certainly,
your
certainly.
argument.
Yeah.
Right.
And I'm not even.
But the underlying law, because you read part of the statute, the government statute, and it said it doesn't need to be conclusively. I'm careful. It doesn't
Yes,
need
sure. It doesn't need to be
proved,
conclusive if
but
there's substantial
but if
questions.
questions are raised,
Yeah.
so it basically, and then they said there are questions raised.
Yes. Yeah.
So they were within the purview of that statute.
Yeah,
But
but
they were ignoring this treaty totally, which is should absolutely go according to Dion,
yes,
right?
yes.
So you're saying that this our cultural imagination of the whale stands in for God. In other words, the whale stands in for the sublime, for what we cannot control, and we should not go there.
Yeah, I
And
mean
so
that's
they
the.
can put everything to the side
Sure,
and
right.
just say, don't do this.
Sure, because even if, when you look at sort of sublime literary theory,
Well,
like I say with Burke and other
Right,
things,
right.
that they would say that you sort of, because we are stunned with the sort of sublime object, that we sort of flail about somewhat.
Right.
And you've already got a court, as I argue in the context of it, is rather anxious when it deals with
Right.
these issues. Yeah, but this just becomes an easy way with it.
Right.
Because there's a lot of, if you go the other direction, which is when I originally read the cases, sorting out, there's the broad level of the Dion precedent, but also when you get down to the questions level, like, to be honest, a lot of the criticisms of the decision say that there even wasn't substantial issues raised, or there weren't even substantial questions. Because, like, when they had both government and outside sources come to talk about gray whale populations, they were all concluding, like, we just don't know. And even a couple of the experts said, when we're talking about take of 1 to 5, it would almost have to be a perfect sort of circumstances for it to have any harm to the species. But we can't make a conclusive statement on that. So, like, even the scientists weren't posing sort of their research or arguments in sort of as like a precautionary principle. That wasn't even the evidence or arguments that they had. So, it was sort of
They had no conclusions.
yeah, it was sort of a weak sort of conclusion that the data provides, but then the court says, well, there are questions, so that sort of meets the substantial level, and, when we're faced with environmental issues, that should matter more than treaty obligations.
And then on the whiteness side, here we have this very inconclusive matter, but who cares about them anyway?
Sure, sure. And, in that whole factoring of that, always having something else sort of come prior as a prior question to recognizing tribal rights, treaty rights, which, are sort of the earliest foundations of, American law, the canons of law, things like that,
I thought it was very odd when I was not aware of this, that Congress could specifically abrogate a treaty.
Mm-hmm.
I mean, that would seem to me to be something you can't do.
Yeah.
I mean, you've got the treaty and it's there.
Yeah.
It literally
But
is written.
Congress has plenary powers, so they can, Native American groups have their sort of treaty rights or any sovereign rights by the, discretionary power of Congress.
So if we have a treaty with
Yes.
France or we have a treaty with whoever, Congress can abrogate, apparently. Well, no, I know, but I mean, if in fact
I guess so. I guess that's.
We can walk away from the treaty.
Yeah, we can walk away. We
But
can
we-
walk. I think Congress can do that. Yeah.
But they would pay a lot more attention to those treaties than this one.
Probably. The court's relationship with Native American groups is very, that's why I want a more nuanced read of it, because it's changed a lot in time. Like in the very beginning, with the Marshall sort of trilogy of decisions,